India Confederation of the Blind. Training workshop on the rights of persons with disabilities with particular emphasis on the visually impaired for AICB affiliates in South India. Sponsored by Danish Association of the Blind.
So we continue with our discussion on various advocacy instruments and strategies this morning. Due to certain reason, we have made a change. So Muthu and I will be doing this session together. I will begin, and if there is any gap, and she'll pick it up later. We will use this half an hour for three purposes. I'm saying half an hour because at 12:30 we have an outside speaker. This half an hour, first we will use to take any questions that you may have on reservations, because we have discussed a lot about that. And then we will talk about various government orders and schemes of the government to facilitate persons with disabilities and how visually impaired persons can benefit. And if time permits, then we'll have something else. So first, if there are any questions or reservation on what we spoke this morning, this is the time to discuss that, next 5-10 minutes. Are there any questions? Please raise your hand, we'll unmute you. On anything that we discussed, talking about reservation, grievance channels, rosters, identification, any of these. So no questions. So then we continue. These acts and policies that we have talked about so much last week and today are fine. They sound very good. But acts by themselves do not make laws. It's very important to understand that. They do not ensure the implementation of laws unless these provisions of the acts are notified by what we call executive orders. Of course, in a court of law, if we go and we say the act is there, even not notified, we can use it. But if I am a government official, I can always say, I don't know your Supreme Court, I don't know any judgment of the Supreme Court, I don't understand the judgments, I'm not a legal person. I don't know acts also, I'm not a legal person, I don't read parliamentary acts. I know what the instructions that come to me from the government by way of what we call executive orders. So we will implement that only which comes by way of executive order, and these executive orders are called circulars or office memoranda, by which all provisions of the schemes, policies, laws of the government are notified to all concerned to public at large for implementation. These are the documents. These are very important documents because ultimately these are the documents that people read. A bureaucrat would read these. He would not read RPD Act perhaps. No, not really, not much. Some good bureaucrats might read, but not all bureaucrats might read. But they are duty bound to read this office memorandum, which are issued by various ministries from time to time. And therefore, to know what these instructions are is important, because these instructions are what we can call notifications in a manner of speaking. And notifications are meant to be then implemented. Nobody can say that I am not aware of this provision because already there in by notification. I can say I don't know the act. I don't understand. I'm a layman. I don't understand legal language. But I cannot say I do not understand notifications. That is sacrosanct. Therefore, the provisions of all the acts, whether it's RPD Act, PWD Act, before that, or any other policy of the government are communicated by way of notification. These are called office memorandums and circulars, and that's why it's very important to know. Now, of course, we'll try to cover some of the important ones. There are many of them, you can well imagine. If I may say, we can go back to as early as perhaps in 1960s, when the first provisions for railway concessions were notified. Even earlier than that, in 1950s, when Bharti Brain was notified in 1952, for instance. That was also a government order. That was a government scheme, policy. Notification of Bharti Brain government. It is also an empowering legislation. So it is not that OMRs to only do with employment. These can do with health, these can do with education, these can have relations with accessibility or any other thing, economics. There also, as in the case of disability laws, there are two dimension. Welcome, Mr. Moria. Yes, pleasure to have you over. Mr. Moria is our lawyer in Chennai. He has done a very important case for us recently. He'll tell you himself about it. Mr. Moria, we look forward to your talk at 10:30. Thank you very much for joining us. Yes. So I'll continue. Aishwarya, please make Mr. Moria co-host, or Muthu, you could do that. Yes. Yes. So OMs are, we typically understand OM and government schemes in terms of employment. That is not the case. There are OMs in terms of education, accessibility, and any other area. And as I was saying, these also have a twin dimension. On one hand, we need to look at office memorandums, OMs, and circulars which are specific to disability. But that's not enough. There are many OMs which are there in place, mainstream provisions, and these also need to be known by anyone who wants granting and realization of rights, because those mainstream rights, as I just said in the previous session, are as applicable to persons with disabilities, including visually impaired persons, as to anybody else. And therefore, these need to be looked into. Also, the mainstream office, what are the schemes? Often we are working in a government office, we don't know the schemes. We are teaching in an education institution, we don't know the provisions for education. So, important to know schemes, important to know policies, important to know government circulars. If you want to go to one place to find out all this, there is MuthuSelvi series. The name is very similar to MuthuSelvi, but there's no coordination, I assure you. MuthuSelvi is not a partner in that. It's a MuthuSelvi series, Vrinda and MuthuSelvi sometimes. And though that series gives all the government orders on everything. There are volumes on anything they can think of, on financial management, GFR, then financial rules, leave rules. There are volumes on reservations for SC, ST, OBC, PWD, and so on and so forth. So there are, it's important to get hold of the latest MuthuSelvi and try to read the OMs related to physically handicapped persons with disabilities. And I would strongly encourage all organizations to have that book with them and read very carefully. I mean, there was an attempt by CSJB to take out a compendium of all the circulars in brain in Tamil Nadu. I don't know whether that has been done. Perhaps it has been done. And that's a very good initiative. Because there are two kinds of OMs. Central government OMs and state government OMs. Because disability is as such a state subject, but because the act was formed, as we told you, India was signatory to your UN declaration, UNESCO declaration of 1993, and that empowered India to frame the 1995-96 legislation centrally. Otherwise, as such, it is a state subject. Similarly, India is a signatory to the 2006 UN CRPD, and that empowered India, that enjoins upon the countries, including India, to bring in place legislations and also amend the existing legislation to ensure that the provisions of UN CRPD are integrated in our laws. This is Article 4 of UN CRPD. There's a commitment on the part of the governments. So they would do this, they would integrate the provisions of UN CRPD in their laws, and that mandated India to bring about a central legislation on disability, which we know as the Rights of Persons with Disabilities Act. But being a state subject, and ultimately there are many policies which are made by states, it's important to also know the state OMs. But as far as disability is concerned, the first thing you should try to ensure is to enforce, and this is often not done, and this is a very important point for advocacy, to ensure, to enforce, or advocate to enforce all the central government legislations and OMs that we are talking about right now, all the central government OMs on disability in your various states. Take stock. This can be a very important advocacy project. Take stock, what are the central government OMs? Whether your states have adopted these or have modified. Any modification can only be to the advantage of persons with disability. It cannot be to the disadvantage. That is to say that while the state governments are free to add provisions to the central government provisions, they cannot take away from the provision of central government provisions. For instance, Madhya Pradesh government, I understand, at one time brought out a resolution, an OM, that they would give 6% reservation to persons with disability. But that was only an OM because the reservation ran into many problems, because they have various quotas for women and this and that. So cross reservation became a problem, horizontality versus verticality became a problem, and the long court cases were done in Madhya Pradesh on that. But the point I'm trying to make is the 6% government can give. It doesn't have to stick to 4% or 3%, because the law says not less than 3% in the case of PWD and not less than 4% in the case of RPD, as far as reservation in employment is concerned. That does not mean that governments cannot give more than 4% reservations. So when we're talking OMs, while the state governments can give more benefits, they cannot take away from the benefits. They should not. Cannot, it may be a controversial subject. They should not. Okay, let's leave it as they ought not to do, take away from the OMs which have been issued by the central government, or the benefits which have been given by the central government as far as benefits to persons with disabilities are concerned. So then we should advocate for that. We will do that. Very good. So the first question is, what are those OMs? And there are hundreds, several, but I'll talk about some of the important provisions. The only OMs, as I said, were more in terms of service provisions or charity. For instance, there were OMs. I'm not getting into details and numbers and dates, those you can find in MuthuSelvi also. I'll talk about the contents of the OM and their implication. I would regard one of the first government initiative was the notification recognition of Bharti as a standardized grade. I think that's very important. I'm saying this on a day when tomorrow we have the meeting of the Brain Council of India. So recognition of Bharti grade was an important step forward as far as visually impaired persons are concerned, because it is that gave all the empowerment and in education and employment to persons with disabilities. Then there were OMs for concessions. For instance, concession in railways. Many states brought about, transport being a state subject, many states brought about OMs concerning concession in bus travel, interstate, etc. There are OMs also in terms of concessions and some kind of preferential treatment, if not reservation, in allotting things like NPG agencies, gas agencies, and gas petrol pump. I'm talking 70s. I'm talking very early 70s, late 60s, early 70s. Now, at that time, these OMs may have appeared as only charity oriented. Seeing these in today's context, I would not say these were charity oriented. Why? Because what does concession do? Whether in railways or in bus fares, and concession started in 60s, has gone on to be extended to many categories. Earlier it was not in first class, then it went to first class, then it was not in second AC, and third AC, and first AC, and then it was extended. There's a number of OMs on that. We will not get into that. But the larger point I want to make is, what does concession mean? It provides you right to easy access to transportation, to mobility, and mobility is a right. Independent mobility is a right in today's RPD Act and UNCRPD. Independence is a right. Accessible transport is a right. So while at that time, when these OMs were brought about, these seemed to be charitable in nature. And perhaps that was the welfare state, because India had declared itself a welfare state. So that was in today's context, we can see that these were not charitable. So the philosophy may have been different. The was to grant those rights of easy mobility, independence, and accessibility to persons with disabilities, which are defined as very important rights in the UNCRPD and RPD Act. In 1974, there was this, following the Kothari Commission on Education in 1966, there was this first government scheme that I was able to see. There were scholarship schemes before that for schools, for instance, for students going into class 9, 10th, and various scholarship schemes. Again, these were seen to be as welfare measures, but today's context, we can see how these were enabling scholarship, financial empowerment, independence is an important factor for our students even today. So we should review these not just as welfare schemes, but also as schemes which are meant to empower persons with disabilities in education, and the visually impaired persons were one of the few beneficiaries of those scholarship schemes. In 1974, we have the first document on education, Integrated Education for Disabled Persons, IEDP, which provides for inclusive education, integrated education beyond class 8 and support and aids and assistance and scholarships in that. This to me was a very important step forward, because first time after following the recommendations of the Kothari Commission, the IEDP scheme, as it is known, recognized the need for integrated education for children. You know, when we talk about integrated education, it deeply impacts and immediately impacts visually impaired children. It was the first time the need was recognized and a scheme was issued for that. This was, to me, the first steps towards what we call today inclusive education. So the point I'm trying to argue is many provisions, many policies, many documents, OMs, which seem to be welfare driven and just incidental at that time, and are not very well known and are not very well recorded, were actually the first steps on the rights on education, accessibility, employment, equipment, etc., that we have today. These documents were the basis for those rights, and therefore those documents should not be forgotten. I hope the noise at the background is not disturbing you, but I have no space to stop the this can go on the whole day, and we cannot stop the workshop or the work both the whole day. Neither the work can be stopped nor the workshop can be stopped. So we both have to go simultaneously. I hope I'm audible enough, because I'm trying to be as loud as possible to beat this noise. So it was in 1974. 1977, I have already talked about the first OM on employment, so I will not go into that. 1981 was a very important year in India, because it was that UN declared as the International Year for the Disabled Persons. It was the first time that recognition of disability as an international entity came to. There were two UN resolutions on integration of mentally retarded, mentally challenged persons in 1971, and integration of disabled persons in 1975, the UN declarations. But these did not seem to foreground disability as an international entity. But when the United Nations declared 1981 as International Year of the Disabled, it was the first time that disability became an international entity, which was a very important rights-based statement, making various governments implement schemes which were only in the pipeline or which they only envisaged. Talking about India particularly, reservation scheme, which started in 1977, was implemented in a big way after 1981 in Group C and D services. One example is school education, where many visually impaired school teachers were appointed in the Year of the Disabled, and many other departments also, disabled persons were employed. The 1986 policy on integrated education talked about integrated education for disabled persons. But that was also the year, as I told you earlier, the first list of identified jobs came. As more and more people started getting into employment, on one hand, there was a talk of reservation in promotion in 1989, which we talked about, but also in 1990, we see the first orders on transfer. There are two orders, and many, in fact, I will not deal with these orders individually, because many orders of the government, OMs of the government, are consolidated in an OM of DOPT dated 31st March 2014. on employment. It's a very comprehensive OM. All of you should look at this OM and read this OM, because all the earlier OMs of on employment for persons with disabilities impacting visually impaired persons also are consolidated in this single OM. So actually speaking, there's not much need to read other OMs now, but some are not. For instance, I saw somewhere in 1991, there was an OM of, there's this OM not many people are aware, and please make use of those. You who are not married, it's a very useful OM for them. The use of an escort for NTC. And it says wherever if a travel is by train, the train or the ticket of the employee and the escort would be on concession basis as per entitlements. But escort would be given only when there's no other member, there's no spouse and any other family member of the employee. When there's no spouse or any other member of the employee, you can travel NTC with an escort. That is a government order, 19 or early, I think in 1991. Now that has very serious implications. At that time, most people were not allowed to travel by air. No. So maybe the government thought, okay, train, we in any case give concession, and we give concession for the escort also. It doesn't matter if we allow an escort. But now that OM has very serious implications because air travels are allowed. So it should be a test point whether now that OM is effective. If that is not, then we need to go to the court for the implement. That can be an advocacy point. Anybody who is entitled to that facility under that OM should try that. And if it is not accepted, then we should go to the court of law to enforce it, because that's a very important accessibility right. The right to leave travel is a right for a visually impaired employee as for anybody else. And how do we go for NTC if we don't have escort, if we don't have family member? No spouse or no family member, then how do we go? So right to escort is a very important right, and we should do something about that. Also, there was an OM on transfer. There's also an OM of having an escort while on official duty, a very comprehensive OM. This is important because many people are sent on field work, etc. They can carry an escort. The ticket would be again concessional. And there's also an OM because many people are getting into IFS. We know from Chennai who is in IFS, Benu. And many other persons with disabilities are getting into IAS. So there is an OM. I'm talking about OMs basically which are not very well known. I'm not talking about OMs which are very common. That's okay, we can read them. But you should know about things which are not very well known. So the escort for abroad, it is said that the first charge would be of the embassy there to make arrangements, or the institution. And if they are unable to make, embassy is unable to make arrangement for your escort there, then you can carry an escort. That's, I think, a very important OM and very facilitating, particularly when the work scope of visually impaired person is increasing multifold. I think that's a very important OM. Then I can see the number of participants somewhat low in this session, and people who have not been there for the session may have difficulty getting the certificates. I just want to say that. Because we are 25, but Muthu will tell me that Viva has joined together. I know that, but even then it's 29, the number was showing more. Yes. So this is also important. Now we come to the 2014 OM on employment. What are the rights it gives? It gives rights, for instance, for reasonable accommodation. Of course, the principle of reasonable accommodation has come in 2016. In last week, Subhash Vashishti talked about it. But it's very important to understand the principle of reasonable accommodation, because we need to use this in our employment and other things. Education also. Reasonable accommodation, any adjustment, modification without putting undue burden on an individual case. I make a distinction between individual cases and collective provision. For instance, if a building has to be made fully accessible, that's not an individual case. It's a different matter that only one employee may be person with disability, but that doesn't matter. It's a collective. Individual cases, me as an Aneja, MuthuSelvi specifically requires a software for her or his use. That is not to do with undue burden. Financial burden is a very subjective term. Who defines undue burden? But demand should be reasonable also. I cannot ask for a helicopter to go from a home to my university. That will be an unreasonable demand. I can also argue human mind is very fertile. We can argue that it's really for accessibility and speed and time on that. But reasonable accommodation, aids and equipment, and transfers. Transfers are important because many people have difficulty. So the OM clearly says that you should be transferred near your place of residence. And now this is a relative because some people's place of residence may be in rural areas officially, but they may be staying in the cities. So the spirit of the OM as close to the place you are living currently, and you cannot give far of branches in banks, in offices. Sometimes there's no choice. The office has only one location in the city. What can you do? If Ministry of Home Affairs is CP or Central Secretariat, then there's no choice. We have to go there. But as such, if there are options, particularly in the case of schools, colleges when there's a transferable job, and banks, etc., where provisions are available, transfers cannot be away from your place. Then there's also a provision for giving flexible working hours. But then again, you see, every facility is good, but we should not misuse that. Flexible working hours is very important. That if you want to come half an hour late, but want to go half an hour later in the evening, that kind of adjustment should be allowed. Because persons with disabilities is recognized have special challenges in home management, other responsibilities, transportation. So therefore, flexible working hours is also a provision which is given in the 2014 law. So transfer, aids and equipments need to be provided. This is a right now. This is notified. So no organization can again deny providing of aids and appliances. Though, of course, again said the demand has to be reasonable. It should not be that I want everything in the world. There's somebody who argued that the person didn't have a computer, wanted a computer. And so I said, fine, you have a computer, but a computer is fine, but you have a computer for work. And the person said, I want both NVD and JAWS. I said, what can you do for those? The person said, well, because I use both of them. Now, if you don't have a computer, where do you use NVD and JAWS both? The person uses NVD and JAWS, but doesn't have a computer. So this kind of demands should be covered. We should ask for only what is realistic, what is genuinely necessary. This is where caution needs to be provided. So aids and appliances. There are also a provision for special casual needs. There are two kinds of needs which are applicable. One, over and above the 8 casual needs which are applicable, there are 4 special casual needs only for persons with disability. These are casual needs. These are not linked to attending of any seminar, etc., which are again 10 days special casual needs, which is different. So there are 2 kinds of needs, 4 casual needs and 10 special casual needs for attending workshop conferences organized by government body, recognized by the ministry. Now this is a problem. What is the recognition by the ministry? Is it grant by the ministry? Or how does the ministry recognize? Is it registration? The new act also talks about registration. So there is a bit of a problem there because you can't attend any conference and avail the 10 days special casual leave. You can only avail when it's organization recognized by the ministry or it's a government body or a recognized body by the government. But those are very important, and this has to be only for disability specific seminars, etc. For others, there are other kinds of needs. For 10 days special casual leave, that's important facility. Reservation, we have talked enough. About scribes. There are many guidelines on scribes, and scribes are very important. Many OMs are there. As we know, in 2013, there was a notification issued after long discussion with the Chief Commissioner and cases where we were also party in one way, because we had also taken up that issue at one time. And then scribe guidelines were issued, which said that scribe could be of any qualification, carrying the earlier part where the scribe had to be 1 class lower, but the innovation should be strong. Also, there are provisions to take the examination by computers for which would impaired persons. Due to certain unfortunate incidents, obviously, which came very highlighted, the government guidelines needed to revise, and now we have the 2018 guidelines, which again return to the point that the qualification of the scribe has to be one step lower. But there is a rider by Delhi High Court on that these riders can be implemented only when there is a pattern of scribes available with the organization. So either you make a pattern of scribes and then implement, or you continue with the old guidelines. Like Delhi University has not yet implemented the new guidelines because pattern of scribe is a difficult thing. Our students keep changing every time. So we have continued the old guidelines, but I know organizations which don't have a pattern of scribes, and yet they are continuing with the new guidelines. If such a thing happens, you can always challenge the guidelines in the courts. If some IBPS or somebody asks scribe forms under the new guidelines, you are asked them whether they have a pattern of scribe. They will tell you yes, they have, and they provide scribe. But that can be a point to be noted. There are also guidelines on housing and poverty alleviation schemes. There are many states which are giving disability pension, which is also under Social Security, and other pensions where there are 5% reservation in the various poverty alleviation schemes. MNREGA also gives 5% reservation under poverty alleviation schemes, and housing also gives you 5% reservation in housing. Now, this is important for government employees or bank employees where housing is available, because 5%, if you don't have a house, 5% reservation has to be for housing. And you can ask for that. Of course, you will lose your HRA. So you have to think, because HRA amounts are good these days, whether it's worth taking a house or HRA. Because if you take a government house, you lose the HRA, perhaps you have to pay the nurses fee, which may make the cost very difficult. So housing is very important. Then there are OMs on education by UGC, various OMs that you should look at, directing the universities to implement RPDX, to provide scribes, to provide materials in accessible format. The aided scheme of the government, which you should look at very clearly, because that gives aids and equipment, appliances to persons with disabilities, and many students can get benefit from that. Unfortunately, people don't apply under the scheme. The money goes unutilized. But many students, there are scholarship schemes by the government. So in all, my time is over, 12:31. All I want to say is that we are waiting to listen to Mr. N.P. Maurya. All I want to say at the end is that all these schemes, and there are many more, which I will not be able to cover, but these are the broad areas which the OMs are there. Please read the OMs. I told you where the sources are. Or AICB website has most of the circulars. Muthu has done a very good job with that. And you can get all the circulars year-wise on our website, on AICB website. Read them, use them, ask for clarification where these are not implemented. Go into advocacy. And this can be one of the very important areas of advocacy. The implementation of various circulars in your concerned states can be a very important area for the advocacy in your states. And yes, so thank you very much. Again, on this, because there's a time for the next speaker, we will take the questions in the very valedictory session, that there is an open discussion and feedback.